Hi, I'm Lillian Chen, and this is Shavi Reno. The issue behind Shavi Reno began after the 1990 census, when North Carolina had to redraw its district map. This new map contained only one majority-minority district. This is where the minority voters numbered more than the majority white population. This map was rejected by the United States Department of Justice, headed by Attorney General Janet Reno, because of the recent changes to the Voting Rights Act. This second map that North Carolina proposed was in accordance with the rules. However, white voters in North Carolina, including Ruth Shaw, stood against what they claimed was unconstitutional gerrymandering that violated the Equal Protection Clause of the 14th Amendment. The plaintiffs in this case invoked the Equal Protection Clause under the 14th Amendment. This amendment states that no state shall deny to any person within its jurisdiction the equal protection of the laws. This case questions the use of race in drawing district lines. Does equal protection under the 14th Amendment apply to gerrymandering? Can district lines be redrawn on the basis of race? The plaintiffs in this case claim that the district in question is unconstitutionally gerrymandered, as it looks to elevate the status of one group over the other. However, the district was only drawn to be in accordance with the Voting Rights Act. This clash between federal law and the potentially applicable constitutional amendment would thus determine the way district lines are drawn around the country. What was the holding? Well, the Supreme Court, with a 5-4 ruling, ruled in favor of the plaintiffs. This meant that the North Carolina map was considered to be unconstitutionally gerrymandered. In addition, race can no longer be the deciding factor when redistricting. This opinion was issued by Justice Sandra Day O'Connor. Her main reason behind the court's decision for reversal was the unusual shape of the districts in question. The districts were very oddly formed, at some point following the path of an interstate in order to connect two areas with large groups of minorities. The intentional gerrymandering was thus very clear and undeniable. The Voting Rights Act can thus only be enacted through a very narrow definition, where race can be one, just not the defining factor when drawing new maps. However, the dissenters in this case would also like to note that the plaintiffs do not seem to have met any harm from the new map. This is also very similar to the concept of affirmative action, where it only seeks to promote minorities for the good of the entire population. Yet Justice Sandra Day O'Connor would still write in her opinion that when a district obviously is created to effectuate the perceived common interests of one racial group, elected officials are more likely to believe that their primary obligation is to represent only the members of that group, rather than their constituency as a whole. This is altogether antithetical to our system of representative democracy. What she means by this is that the gerrymandered districts will ultimately lead to one group being represented over others, where one group is prioritized over the entire population. This idea is contradictory to our founding principle of one man, one vote. The legacy of Shavi Reno on the law? Well, this had a major effect on redistricting, where race can no longer be the deciding factor when drawing new maps. The government became colorblind in matters of gerrymandering, where any law concerning such affairs must follow 3 principles. 1. They must have a compelling government interest. 2. They must be narrowly tailored for its goal. 3. It has to have the least restrictive plan for implementation. This would affect the way that new maps are drawn around the country and truly demonstrate the impact of Shavi Reno on history.